I, Megan, that's the subject.
Okay, good morning. Good morning. This is the regular open meeting of the New Mexico Public Regulation Commission on Thursday, May 2nd. It is exactly 10 a.m. and we'll get this meeting started with the roll call, please.
Thank you, Commissioner. As the public may have noticed, the chairman, Commissioner O'Connell, is not in attendance today. So Commissioner Aguilera is going to be acting as the chairman for today's meeting. So I'll call the roll appropriately. Commissioner Ellison.
Present.
Commissioner Aguilera.
Present.
So we have 2 of the 3 commissioners, and that's a quorum. And so we can go ahead and proceed.
Thank you. And just for transparency, we have a very sophisticated way of figuring out who is going to lead this meeting, which involved a coin that Commissioner Ellison flipped. I asked to see the coin and he wouldn't show it to me, but you know, apparently I lost or won, or however you want to look at it. So we'll go ahead and get started with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico, to be a symbol of perfect friendship among united cultures. So next on the agenda, we have consideration and approval of the agenda, which includes our regular topics, including several items on the consent agenda, 8 to be exact, and 2 items on the regular action items. Commissioner Ellison, do you have any changes that you would like to make to the agenda?
No, thank you. I have no objections to the agenda as it stands.
Okay. Likewise, I don't have any changes to suggest. So with that, we'll move on to the next item on the agenda, which is public comment. Patrick, do we have anybody for public comment?
Commissioner, we do not have anyone signed up.
Okay. Do we have anybody in the room? And it does not look like we do. Okay. And next on the agenda is announcements, and I'll look to Mr. Scott Cameron to see if you have any announcements for general counsel.
Thank you, Commissioner. Going to keep it simple this week, and I do not have any announcements.
Okay. And Commissioner Ellison, do you have any announcements that you would like to make?
I just have a few announcements about some upcoming events, and I'll certainly leave it to you, Commissioner Aguilera, to speak more about the May 17th markets workshop. I did want to bring up that we have a scheduled workshop for the morning of May 15th on cost benefit analysis and its role in grid modernization. For it's another one of our workshops, the fourth in our series, where we are working towards a rulemaking in grid mod, integrated distribution planning, and that's from 9:30 a.m. to 12:30 p.m. on May the 15th. We have a external speaker from a firm called E3, Mr. Sneller Price. I think this will be an informative workshop, and we also are asking utilities to make a brief presentation as to their views on cost benefit analysis and I guess benefit cost assessment in general as it relates to grid modernization at that workshop. Also on May 15th at 1 o'clock, we have public comment on our notice of proposed rulemaking on reliability. It's been pointed out to me that we only left 30 minutes for a break in between the two sessions, and based on how we've done in the past, it would be pretty nice to have 30 minutes in between the two sessions. On May 16th at 3 p.m., we do have public comment on the New Mexico Gas Company's stipulation or settlement in their rate case that is before us.
Thank you for those. And the other one that you briefly mentioned, which I will speak more about, is the workshop on regional markets. We'll be holding another one on May 17. And if that notice hasn't been issued yet this morning, it will be issued today. For that workshop, we will have presentations by the California Independent System Operator Corporation and Southwest Power Pool, and they will both present their day-ahead market designs, one of which has been mostly approved by FERC and the other one is currently pending at FERC. And so that's what we have on the agenda currently. There is a chance that we might add another conversation with respect to the Pathways initiative that has been discussed in the Western Interconnection. And so those are the two presenters that we know that we'll have for sure is CAISO and SPP. So I want to thank them in advance for coming to present those market options. And the utilities, obviously, I'm sure they, PNM and EP will be here for that. And hopefully we could also engage other stakeholders in a Q&A portion of the workshop. That's all I have by way of announcements. Next on the agenda is announcements with respect to new employees. Do we have any?
Mr. Chair, I'm very excited to welcome Mr. Nick Rossi, who just started with us this past Monday. He's joining us in the legal division, and he comes to us from the Interstate Stream Commission. Nick?
Good morning, Nick.
Good morning, commissioners. Pleased to be here. As Ms. Curry stated, I'm recently from the ISC. I've been there a year and a half. And prior to that, a prosecutor in Clovis and Port Tallis. I look forward to the opportunity to work here. Thank you.
Welcome to the team.
Thank you. Welcome.
Okay. The next item on the agenda is Employee of the Month, and it is my honor to read the recitation for the Employee of the Month. So the Employee of the Month is Naomi Velasquez. She's an economist in the Utility Division. Naomi assisted the Transportation Division staff in accounting review in 2 transportation tariff and rate cases recently. Naomi was a pivotal financial analysis resource and helped lead staff to a settlement and stipulation in both cases. Additionally, Naomi was instrumental in reaching agreements with 2 separate ambulance services. Naomi's hard work and dedication is appreciated and should be recognized. So thank you so much, Naomi, for that, and congratulations. Okay. Rolling through this. Next on the agenda, we have approval of prior meeting minutes, and we have 4 sets of minutes for special open meetings, regular open meetings, and public comment hearings that were held on March 28, April 4, April 18, and April 19. I think I had very minor just corrections to one of them, and I think it was maybe the April 4 regular open meeting agenda, but aside from that, I didn't have anything additional. Commissioner Ellison, do you have any changes that you would like to make to those, or?
I just had one minor observation on the April 18th minutes. It was Commissioner O'Connell who adjourned the meeting. That was really the only issue that I saw.
Okay, thank you. And while we're on that set of meeting minutes, I just want to give a quick shout out because I thought that the summaries of the public comments that were provided were very well written. It was very interesting for me to go back and read those public comments, and I just generally thought that it was a really good product. So thank you for those meeting minutes and the others as well.
I certainly second that. I mean, the court reporter really did go above and beyond and not just writing word for word what people said, which would have been, of course, a very long document, but really captured the essence of it. So that was nice.
I move then to approve the meeting minutes with the change that Commissioner Ellison suggested to the end of the public comment hearing.
I second.
I'll take the roll on that one. Commissioner Ellison,
Aye.
Commissioner Aguilera.
Aye.
The motion to approve the 4 sets of minutes with the change to the 418 public comment hearing minutes passes unanimously, Mr. Chair.
Next on the agenda, we have consent action items. We have 8 utility items on the agenda. I do not have any comments or questions on those. Commissioner Ellison, do you have anything?
Commissioner, the only thing I might mention is the 5th item, case 24-133. I thought it was interesting that we seem to be issuing the same blanket variance year after year since 2013, and I guess the stated rationale was that the federal law is continually changing, and it's it would be hard for us to revise our rules to keep up, yet it seems like we're making the same variance year after year. And I just wonder whether, there's any appetite to have a look at that rule and maybe make a revision so that we're not making the same variance year after year. But I have no problem with making this variance now.
Yeah, thank you. I noticed the same thing, and in speaking with OGC, I came to the same conclusion that it was dependent on some rules that the FCC has not yet adopted. Yeah, I certainly would be open to discussing a change there as well. Of course, if we make that change, then the FCC will, adopt these rules, and we need to update ours. But I think that it's certainly something that we could entertain. I do actually realize now that I do want to highlight one other item, which is item 2. This is docket 24-00157 UT. And this is related to the Efficient Use of Energy Act. And we have I probably should have requested a presentation on this, and did not think about that in time. Yeah. So apologize, Mr. Lundin, but I am going to move this item to the regular action, just so we could get a brief presentation on that item. Okay. So unless there are any further comments or questions, I move to approve the consent action items with the exception of item 2, which we will discuss in the regular action items section.
I second.
Commissioner Ellison,
Aye.
Commissioner Aguilera.
Aye.
The motion to approve of the consent action items with the exception of moving item number 2 to the regular agenda passes unanimously, Mr. Chair.
Okay, and then we could maybe take that as the third, that being the rulemaking docket as the third item in the regular action section. Okay, and we do have the regular action items up, and we have Miss Katie Lane presenting the first item. Please go ahead.
Good morning, commissioners. Before the commission, the first item is a string of docket numbers starting at 240064 UT all the way down to, well, this is not consecutive, but all the way down to 2411 UT. These are all formal complaints filed by a certain Odell Electric Services between the dates of March 1st and March 26th of this year. The complaints allege that PNM has either failed to disconnect or reconnect and energize temporary poles in various project sites and seeks compensation for DR Horton for the expenses incurred because of these alleged delays. The complaints cites, and I quote, PRC 410 rule as the rule allegedly violated by PNM. The complainant, Odell Electrical Services, is a business entity and is not represented by legal counsel. Complainant is also no stranger to filing formal complaints. One was filed in 2022 and several were filed also in 2023, all against PNM. The 2022 complaint, which is specifically 22-00268 UT, the allegation is that PNM failed to energize some projects in a timely manner and sought compensation for the missed time. The commission at that time dismissed that complaint, citing lack of jurisdiction to provide damages or compensation in these cases. And the case cited was Summit Properties, Inc. versus Public Service of New Mexico, a 2005 New Mexico Appeals Court case number 90. The remaining cases filed in 2023 were also dismissed without prejudice. The allegations also in that were that PNM failed to energize poles and other delays in installation and also sought compensation. In that matter, the commission issued an order urging the complainant to seek legal representation, citing Commission Rule 1.2.29D, New Mexico Administrative Code, that requires entities other than individuals filing formal complaints to be represented by legal counsel before the commission in formal proceedings, which is what a formal complaint is. The commission also ordered the complainant to amend and refile the complaints to comport with Commission Rules 1.2.2.15. The order also stated that failure to comply with could result in dismissal. No complaints, amended complaints were filed, and on June 21st of last year, 2023, the commission dismissed those complaints. This year, we also see a string of complaints filed yet again against PNM. In this case, the complainant continues to be not represented by legal counsel. OGC has drafted a order dismissing the complaints without prejudice. And it's also, that clearly states that the dismissal is, does not address the merits of the allegations. And if the circumstances alleged in the complaints have not been resolved, the complainant via an attorney may resubmit the complaints in compliance with commission rules. And I'm ready for any questions you may have.
Thank you for your presentation and work on these complaints. I want to highlight one paragraph on here that well, just to talk about it first. It says that this is paragraph 10, the commission is not authorized by law and this does not have jurisdiction to order damages to reimburse for claims of alleged damages, and such matters must be brought before magistrate or district court. I just want to highlight here that the complaints are being dismissed without prejudice on procedural grounds, that the complainant has not retained an attorney as required by the rules. I do think that in a way this paragraph might go beyond what we need to do in this order. I believe that not speaking to the merits of the complaint here, but just for sake of argument, if the complainant retained counsel and came back and demonstrated that the utility here has violated a rule, I believe that the commission would have the authority to require an appropriate remedy. And so I don't want this paragraph 10 to be misconstrued as though the commission cannot do anything here. And so I guess, you know, I'd like to hear what you think, Commissioner Ellison, but I may suggest deleting this paragraph entirely.
You know, I guess my interpretation of this paragraph is that we don't have jurisdiction to order, you know, damages from third parties, such as in this case, the complainant sought compensation from D.R. Horton, and that seems to be pretty clearly something that, we cannot compel DR Horton to pay for damages, but, I certainly agree that if, the complainant were to demonstrate that the utility had not followed rules and regulations properly, that that would be a different matter that would be within our jurisdiction.
Okay, I see where you're coming from, and I understand that there could be proper context for this paragraph. So I will not propose to delete it. And I think, yeah.
May I say,
Sure.
so, also, the complainant is seeking compensation for DR Horton. So,
Yeah.
Why is the complainant seeking, why is DR Horton not
On the
filing something if that's the case?
it's a very valid question.
Right, and this is why our rules require for entities to secure counsel. So I would be fine with deleting paragraph 10, or maybe Ms. Lang, there's a simple word fix that we might use to clarify that, we're talking about third party damages or to seek compensation for third party claims.
I'm okay with deleting paragraph 10 in its entirety.
Okay, that's fine.
So I will delete paragraph 10 and
Okay, I will move to adopt regular action item with the deletion of paragraph 10 in the current draft order that was provided by OGC. Maybe we could get a second, we could, open up for further discussion if needed.
I second.
Any further discussion?
Commissioner Aguilera,
Aye.
Commissioner Ellison.
Aye.
The motion to approve of the order with the deletion of paragraph 10 passes unanimously, Mr. Chair.
thank you.
Thank you. Okay, and we next have a presentation by Mr. Kevin Getko on regular action item 2.
Good morning, Commissioners. This matter is case number 23-00380-UT, which is the application of Painted Desert Energy for location approval of a solar facility in Chibala County, New Mexico, which was filed November 17th, 2023. It is for a 400 megawatt solar energy facility and an up to 200 megawatt AC coupled battery energy storage facility, which is located on 3,885 acres of privately owned land. This matter was assigned to hearing examiner Tatiana Perez Valero, and she conducted the proceedings. Ultimately, the hearing was vacated through an agreement between Painted Desert Energy and staff, who were the only two parties. The hearing examiner's recommended decision found and concluded that the application met all statute and rule requirements and that approval should be given. Those statute and rule requirements are the location control statute, which is NMSA 6293, and met the commission's location rule, which is 17.9.592 NMAC. Some minor points. The hearing examiner established that the record shows that the project will comply with all applicable air and water pollution control standards and regulations, which is a focus of the statute. That Painted Desert Energy has established by a preponderance of the evidence that the solar facility will not unduly impair environmental values of the site area. It was determined that no location approval is required for the switchyard and substation, as they fall within the safe harbor provision set out in section 6293, as well as in rule 17.9.592.15. And it was recommended the applicant shall file quarterly compliance reports with the commission, identifying progress made with respect to any phase of the project and the applicable terms and conditions included in the commission's order. Shall report on any deviations from the terms and conditions of the project, and shall provide notice of the date that the project becomes operational. The order that you have before you is a final order adopting the recommended decision with modifications. Those modifications are largely for clarity of the order and to make sure that it reads well, given that the recommended decision was written in terms of what should be adopted. But it doesn't substantively change the majority of that recommended decision, other than on one item, which is with respect to the battery storage. The recommended decision recommended a finding that the battery storage was not generation and therefore was not, did not need approval. The final order that is before you clarifies that the commission is not making a determination of whether the battery storage is generation, but finds that the location of the battery energy storage facilities is appropriate and acceptable. That is the summary of what has occurred, and I stand for questions. Thank you.
I appreciate the presentation. Thank you for that. Commissioner Ellison, did you have any comments you would like to make?
Yes, Mr. Chair, I would like to make some comments here. I think it is relevant, the point about the battery energy storage, whether it is considered generation or not. I agree that determination is not required in this case, since the battery is co-located with the solar, and that area was studied as a part of the environmental permitting process here. However, you know, I can certainly envision other cases where the storage may not be co-located with generation, and if we take this interpretation that storage is not generation, we could be in a situation where no one is reviewing the the location of storage, I think this is relevant. There was a recent FERC decision around some pump storage hydro projects on the New Mexico Arizona border back in February. And it was a FERC jurisdiction because it's in tribal lands. But the Navajo Nation and certain groups felt strongly that they had not been properly consulted as to the environmental impacts of those pump storage hydro projects, that the developer did not assuage their concerns about the project's potential impacts on groundwater. And normally FERC has allowed projects like this to go forward and allowed the debate to continue. In this case, they dismissed the applications without prejudice over the concerns of the local community. If this project had not been on Navajo lands, it would have fallen under our jurisdiction. However, if it were considered that storage is not generation, then we would not be making a locational approval determination. And to my knowledge, no other entity in the state would be making that determination. It's my view that when storage injects power into the grid, it does act as generation. I think that having an inquiry on this subject is warranted, and I would be interested in the views of my fellow commissioners on this topic. Clearly, the statute on the certificate of convenience and necessity was enacted before there was such a thing as battery energy storage. The Public Utility Act is silent on battery energy storage because it was adopted before there was such a thing. So, this seems to be, an unsettled area. Also, I'm going to mention there was an RD previously adopted by the commission that asserted that that storage was not generation. That in turn was based on a FERC decision that asserted the same thing. That FERC decision was appealed to the U.S. Supreme Court. The law is really not settled on this issue. Again, maybe I'm going into too much detail here, because for this particular case, I have no issue with it. Since it is co-located with generation, we are making a locational approval for the generation. The location is appropriate for this grid scale battery storage. But I just think for the future, we want to think about cases where we've got grid scale storage that is not co-located with generation, and where there may be significant environmental concerns, and we may want to have the authority to make a locational decision.
Thank you for that explanation. I'm sure that's helpful for a lot of people listening. With respect to the adoption of the recommended decision at a high level, I agree with the approval here. I also agree that it is unnecessary to make a finding as to whether battery energy storage here qualifies as generation, as that is not an issue that is appears to be contested here. I think you're right that a larger discussion involving other stakeholders, that are normally involved in PRC cases would be beneficial before making any kind of decision. So I appreciate the recommendation to eliminate that finding from this order. Battery energy storage is unique. I mean, it really does not have another resource that you can compare it to quite easily. I mean, I think the pumped hydro example it informs here, but even then the characteristics are a lot different, because you can really there what you're storing is water, and then you can use it to create generation. I think that's a closer explanation for generation than battery energy storage is. But I'm not ready to make any findings on that. I think when we have a larger conversation on that, I would appreciate that record being informed by what FERC has done, what other jurisdictions have done, because it's not an issue that is unique to us. And so thank you for raising that. I look forward to when the time is right, having that conversation. For now, thank you to staff and the hearing examiner and our counsel here for their work on this. I don't have any other comments on this.
I'd like to make a motion that we adopt this order.
I second.
Commissioner Allison?
Aye.
Commissioner Aguilera?
Aye.
The motion to adopt the order as written passes unanimously, Mr. Chair.
Thank you.
Thank you. And then we have one more item that we added, and Mr. Robert Lundin will be presenting next. And this is the item that was consent action item number 2 that was moved to the regular action item.
Good morning, Commissioners. So this item is in docket number 2400157-UT, which does not yet exist. The proposed order for you today would open this docket to consider a rulemaking for the Efficient Use of Energy Act. The last time this commission considered Efficient Use of Energy Act rulemaking was in 2019, and it adopted a new rule in 2021. However, that rule does not address one aspect of the Efficient Use of Energy Act, which is germane for our consideration. In section 62.17.5G, there is a requirement that no later than June 30th, 2025, the commission shall adopt through rulemaking energy savings targets for electric utilities for years 2026 through 2030, based on cost-effective and achievable energy savings, and provide utility incentives based on savings achieved. So that is, approximately 14 months from now. We have a hard deadline and statute to pass a rule. In the current compliance period, which is 2021 to 2025, public utilities have to meet a 5% of their total kilowatt hour sales savings target. For off the top of my head, I recall from, I believe, PNM's cases, that's roughly like an 80 gigawatt hour a year target. And they achieve that through the programs and energy efficiency measures that they apply for approval for every year. So their portfolio programs, they seek to reduce energy usage, and those savings are then tracked towards compliance with this kind of 5-year target. However, the requirement in the statute for the commission to pass a rule does not give the same type of guidance for what that energy savings target should be. It leaves it open. So theoretically, the commission could move forward with a similar, 5% of kilowatt hour sales goal, or it could completely, reimagine what this kind of paradigm of energy savings looks like. Additionally, it asks us to take into consider incentives. In the past and currently, incentives have been based on basically a percentage kind of adder that they get to put in their energy efficiency rider. Roughly, around 7%, something like that, 7 to 8%. But it's based on the energy savings that they achieve, and usually the incentive adder increases with more savings achieved. So that's kind of how it works currently. But as the statute is written, that is all potentially up to change or to remain the same. But given how kind of long these processes take, we really need to get the ball moving and open this docket and get it started. So this order would simply open the docket and ask questions of our electric IOUs and staff. The next kind of reasonable step either would be to issue further bench requests or potentially employ a working group to develop a proposed rule. However, we're kind of starting from ground zero with this one. So if there's any questions, I can answer those for you.
Well, thank you for that presentation. And sorry that I did not give you a heads up in advance. That I was going to seek to move this. I just wanted to highlight this because this is a potential rulemaking, and appreciate the presentation and the order that you've drafted for us. I don't have any comments or questions to ask at this time. I'll turn it over to Commissioner Ellison to see if he does.
Thank you, Mr. Chair. I guess, I would be interested in hearing what utilities think around, what sort of utility incentives are appropriate. And, I do agree with Mr. Lundin here that this is an opportunity for us to rethink how these energy efficiency programs work and how they're incentivized. And so I look forward to engaging with the utilities and see how this progresses.
Thank you. So with that, I will move to adopt this order.
I second.
Commissioner Aguilera,
Aye.
Commissioner Ellison.
Aye.
The motion to adopt the order passes unanimously, Mr. Chair.
And I would make one more comment.
Yes.
I just want to correct something I said. I said the utilities file their plans annually, which is incorrect. They file them every 3 years. And because of that 3-year outlook, some of the current plans reach into this 2026 period. So in those dockets, we've had to devise kind of makeshift targets for those compliance years, which is kind of one of the, I guess, drawbacks of not having a rule yet in place. Sorry, I just want to note that.
Thank you. Well, we're doing good time. So that concludes the regular action items on the agenda. So now we're on to item 10 on the agenda, which is discussion items. So quite convenient. We have Mr. Lundin here who will be presenting on the first item.
Thank you, Commissioner. And so this item is on the discussion agenda, so I'm not asking or proposing an order to be voted on. I'm just here to talk about it, to get it on your radar, because you know, with the several rulemakings that we have going on, it's easy to kind of lose track of some of these. So talking about it here will kind of serve the purpose of getting everyone's attention. So this is docket 22-00140. And this is a rulemaking related to an RPS rule for rural co-ops. This one has been several years in the making as well. In 2019, Senate Bill 49, which contained the Energy Transition Act. They also amended the Rural Electric Cooperative Act, increasing the RPS standards for the co-ops. From that Senate bill, the commission initiated a rulemaking. However, the rulemaking was bifurcated and then separated into separate phases, and then it was appealed. So in that kind of convoluted process, the commission decided that the co-op rule would be considered separately. And thus staff in 2022 petitioned the commission to open a new rulemaking for the co-op rule. In response to that, the commission impaneled a working group. The working group consists of it's every stakeholder who has participated in this docket, but not necessarily every stakeholder who may want to participate. But it's composed of staff, Tri-State, Western Farmers, NMPRC, which is the association that represents the co-ops, and Kit Carson. So those are all the parties that have participated in this docket so far, and they're all represented in the working group. So the working group evaluated and analyzed staff's proposal, and from there developed a working group's proposed rule, to which the commission has issued some bench requests back and forth with the working group to further kind of pare that down and understand it. And then what I've been working on is developing a commission's draft proposed rule. So I've taken the working group's draft and tinkered with it a little bit further to get it to a point where, as we are now, this could be issued as an OPER. It's ready to go. The only thing left is for the commissioners to sign off and be comfortable with the proposed rule as we have it. I would like to mention that there are 3 kind of open issues that will be addressed in a commentary phase. The first relates to green hydrogen. The working group was a little bit split on whether or not green hydrogen should be included in the draft rule. The second relates to whether or not there should be a REC multiplier for generation assets based in New Mexico. Again, the working group was a little bit split on whether or not to include that. And then the third open issue is how to demonstrate compliance with the 2050 zero carbon standard. So as the draft rule is written right now, there's no compliance mechanism for that, but we have 26 years to kind of figure it out. So it's an open issue for this rulemaking, but there's not a proposal on the table for that. Additionally, there's a few extra kind of cleanup issues from the last rulemaking docket that have made their way into this one, relating to life safety code violations and whether the commission has authority to adopt them. And then everyone's favorite, regulatory disincentives, which is currently not ripe to be considered as it is on appeal to the Supreme Court. I think I've said everything I need to say. So if you have any questions or if you have any further discussion, please let me know.
Well, thank you for the update, especially in this forum. I think there are certainly some interesting issues here to discuss. And I focused on this some, but also recognizing that it was not for potential action. It was just looking at the issues and not necessarily the order. So glad that we're not voting on that today. And Yep, thank you for putting it together. I certainly will want to schedule another meeting with you. I know we already spoke about this briefly. I don't have any comments aside from that. Commissioner Ellison?
Thank you. There's one item that really stands out to me here, and that is the fact that most of our electric co-ops do receive power from tri-state. However, I'm not sure that they will be providing us information as to renewable portfolio standard compliance. Is that correct? We're putting the onus on the rural electric co-ops to report, yet they are heavily dependent on tri-state as to their generation mix.
Yeah, so the co-ops who have their contract with tri-state don't really have any control over their resource portfolio. I do understand that I think they're on track or close to being on track to RPS compliance from tri-state's generation assets. But the rule would require the co-ops to provide annual reports, which would hopefully contain all the information that you want to see. And we've talked about, we're gonna kind of work on that section to make sure it captures everything. Additionally, the rule contains some requirements for the generation transmission co-op, so tri-state and Western Farmers, to provide some information, but off the top of my head, I can't tell you exactly what that is. But the rule does kind of differentiate between distribution cooperatives and the GMTs.
Yeah, I think that's an interesting topic. I've learned that Tri-State does an integrated resource plan before the Colorado Commission. So, those documents are available. They also buy power from WAPA. They buy federal hydropower. And, given that they supply both Colorado and New Mexico co-ops, I would suspect that they have some latitude as to how they assign that hydropower. But I do think it's an interesting area, and we may want to think about what kind of reporting we can get from Tri-State, and what can be done if we're not getting compliance on the RPS side.
Another comment I like to make, I kind of implied this, but because the draft proposed rule as we kind of have it now is largely based on the working group's work product and staff's work product. I think it's great that there's a lot of consensus and that all the stakeholders who are involved have worked on kind of building this. And it's probably as close to a consensus draft rule that you might be able to get in this space. However, I think it is good to remain skeptical about a rule that's, potentially drafted by industry that's going to apply to industry. So we'll just keep that in mind. But I do want to note that this is a product of pretty much across the board collaboration, which is a good thing.
Not all settlements are equal. I appreciate that comment, Mr. Lundin. And I might just add, I did have a conversation with Mr. Lundin about the reporting requirements. It is somewhat puzzling to me that, this industry group came up with sort of a laundry list of things to report on, but, I didn't see some of the headline things that I would really want to see, like the percentage RPS compliance. There was a lot in there about, demonstrating the Regis, rec certificates and about canceled rec certificates. And, I'm just afraid that's how we get to these 300-page reports that don't really tell us what we want to know. And so if we can do some upfront thinking about, what is it that we are really most interested in, then we could, cut down on the size of these reports and get something more relevant.
Yeah, thank you. Thank you for highlighting that about Tri-State. Just being in other sort of regional conversations, Tri-State is facing similar requirements in Colorado, as you've noted. And so I know that they are thinking about this. Just sort of as a side note, I'm familiar with sort of these issues with Tri-State and their wholesale electric service contracts, and so their members can purchase up to 5% of their own generation, but the rest of it has to be purchased from Tri-State. And I know that FERC recently approved a mechanism for how you can, as a member, exit Tri-State. I don't know that, and some members have already done that. I think most of the members who were still expressing an interest in potentially doing that were not in New Mexico. But it is, I guess it's beneficial that the rest of their footprint is in Colorado as well, and kind of beyond Colorado, but I would say mostly these two states. So that gives more to think about. Another reason, thankful for bringing this already.
Great.
Thank you for that.
Thank you.
Thank you, commissioners.
So next we have a presentation by Jason Montoya. Good morning.
Morning.
Commissioners. Situated. Be able to see that. Thank you for having me. I want to touch on a few things before I speak to the slide and graphic that is currently projected on the screen for the audience and yourselves. First off, we do have one vacancy in the Pipeline Safety Bureau. Unfortunately, we lost one of our most senior persons to the industry, as I think I've shared with you all before. That is our competition. And the good thing is he did move out of state, so it's not like he's in our backyard. So at least I'm not going to have to deal with him on any of our inspections and debate and argue, because he knows how we work and how we practice. So, good for him and his family. But to no surprise, in addition to that, we are currently working with both ASD and the Human Resources on that 10-person expansion for the program. If you haven't already heard about it, I hope it'll be on your local billboard soon when those are advertised and published and available for applicants to consider applying. We have been recruiting throughout the state during our inspections and seminars and conferences and all the other events that we've been a part of this year. Some other business and personnel matters. The Pipeline Safety Bureau is currently working with industry on a proposed rulemaking specifically focused around addressing dated language and align us with national best practices. For the most part, the majority of that rulemaking will be damage prevention related, but I think we are now in a time where our Pipeline Safety Act and pipeline safety rules need a complete overhaul. They've been dated. There's been a lot of work on the Hill. When I say the Hill, obviously the Congress and all the rulemaking that they've been going through, that we just need to do some updating here locally as well. So that should be forthcoming in the next couple of months, I hope. The good thing is that my approach has always been to try to work out any issues or concerns the industry might have prior to filing to make the commission and staff's job a lot easier. So all the legwork on pipeline safety matters is going to be done before we file that. So I don't anticipate any objection or opposition to the rulemaking. That's the intent. We also have a third-party damage reporting tool called Earth Utilisphere that was implemented and went into effect December 15th, 2023. And as required by rule, all underground utilities or any utility company that owns infrastructure underground, of course, that has been in conflict or damaged during excavation activities is required to submit a third-party damage report within 30 days of occurrence, regardless if they're at fault or not. And that is in our rules. And so we actually issue notice of probable violations if they fail to submit that report, because we depend on it, right? When we make our conclusions and try to identify areas that need attention or can be approved upon within our industry. So we do take it pretty serious. There are 3 team building sessions I'm happy to announce that will be taking place between now and June 30th with our pipeline safety group as we prepare for a significant increase in staff, and just kind of setting the stage on what to expect and how important it is for us to continue to communicate and grow and develop as a group and as a team. A couple of cases that I wanted to just touch on briefly. One that you're familiar with, one you will be familiar with, is the New Mexico gas incident that occurred last September. I'm happy to announce that the parties have settled that case. It included several corrective actions that have already begun to be implemented on behalf of New Mexico Gas Company. The positive thing there, Commission, is that it doesn't only apply to the Albuquerque metropolitan area. If it is something the Mexico Gas Company and Pipeline Safety Bureau agree to adopt in their O&M plan, it's applicable to the entire state. And so obviously the ultimate goal is to prevent recurrence and not have these catastrophic events again. There was also a civil penalty assessed, about $191,500 that we settled on, and that has since been paid as well. And so that case, in my opinion, has been closed successfully, unsuccessfully because of the results, but successfully, with the understanding that we're hopefully in a better place we are now with the procedures than we were then. The other case that is required statutorily on an annual basis is the pipeline safety fee assessment. That is due May 1st by statute. So that was obviously filed yesterday, and it'll be forthcoming before the commission. Our goal is to always have, and I spoke with Mr. Kevin here about the timing, and we'll be having a hearing towards the latter part of the fiscal year, which just helps us with the accounting process, because we don't want to receive checks this fiscal year that are applicable to next fiscal year and have to deal with that on the books. As far as training goes, we're going to be focusing on some very specific training on a case-by-case basis. Unfortunately, Mr. Kevin Duke, the one that recently resigned, was an expert in cathodic protection and corrosion. And so we have a gap there that we'll need to fill with somebody and look into some specialized training. Some other areas include welding, tank inspections, and just becoming familiar with all the new rules. And so we got a lot of legwork there to catch up on. There's other career-related training that is being provided via a subscription to Fred Pryor. If you're not familiar with Fred Pryor, there are thousands of training opportunities that come along with that subscription. So we will be focusing on project management, technical writing, and effective communication with those subscriptions. Now I'll speak to the graphic unless you want to pause and have any questions of what I've already covered.
I don't have any questions. I'm just sitting here, recognizing that your division has a lot going on, and we'll be seeing new people, and in terms of development and making sure that people are prepared to do that job. I'm grateful that we have you to lead them. So just wanted to take a moment to say thank you.
So, yeah, thank you, Mr. Chairman, Commissioner. As far as the activities goes, you can kind of see it here on the screen. The 28 consists of 3 standard comprehensive gas inspections, which is our most common type of inspection. So we do throw a lot of resources at that component. It's typically a 5-day in-person setting where we're going through books and procedures and sitting across tables like we are now and having a dialogue just to ensure compliance. We've had 2 drug and alcohol inspections, 1 distribution integrity management inspection, and 22 master meter inspections. I think it's surprising to a lot of people that we actually have jurisdictions of trailer parks and universities and colleges and mobile homes and even RV parks to a certain extent under our master meter program. So that can entail a lot of work. Excuse me, sorry, I've got a little sniffles here. We have had 556 excavation damages reported this calendar year. And I should say, I'm reporting to you on a calendar year basis because that aligns with our grant obligations. I know we operate under fiscal years on the federal government and state government, but the actual funding for grants is January 1 to December 31st. So, and you know, I don't want it to get confused with any other fiscal year, just to clarify that. Of the 556 damages that have been reported, we've investigated 403. We've conducted 2 outreach days, which involved about 29 people. And we have since January 1 mailed 248 notice of probable violation letters for damage prevention situations. And that's independent of pipeline safety. The other couple of activities I have here on the screen are the online class attendance. Initially, when we determine somebody is at fault or out of compliance, we'll send them a notice of probable violation letter and give them an opportunity to take an online training class and attempt to educate the community and also prevent recurrence again. And so that is actually costs a little bit of money and time. It's about a $250 fee to take. It's with a third-party consultant. There are opportunities that me and NM811 provide throughout the state. And that's obviously free of charge, but it's more for a bigger setting or a larger group of people. And Mr. Chairman, Commissioners, that's really the first quarter report I have for today.
Thank you. With respect to the excavation and damages reported, how does this compare to previous years? We only have data for the first quarter so far.
We are pretty static, if you will. We typically see around 2,500 a year. And so keep in mind, this include winter months where there's not a whole lot of activity in northern New Mexico. That is now ramping up. So that 556 will probably grow the second and third quarters. And then it obviously everybody's in a hurry to beat the winter weather. And so they start excavating quite a bit, especially in northern New Mexico. I think there are some communities that actually implement an ordinance that doesn't allow excavation during certain, seasons. So I think it's pretty on track. Our goal obviously is to see a downward trend. I mean, we're always working at that. I think there's been times where we've seen an upward trend because of the enforcement. And what I mean by that, Commissioner, is we send letters notifying them that you shall report when an excavation damage occurs. So then they become aware of it and the number should increase, right? And then, but over time, I should see it plateau.
Okay. Okay, thank you.
You've mentioned one incident in Albuquerque last year on the gas distribution side. That's one of these 4 that you've got in the table.
Mr. Chairman, Commissioner Elson, no, that would have been reported with the end of the year progress report that I gave you guys a month
Okay,
and a half ago.
this is
These are
first
new
quarter.
since January 1.
Okay.
And they haven't maybe caught the attention as the significant incident because they're a little minor. They still meet the reportable thresholds, but it was turn a valve and you got the situation under control, where we didn't necessarily need to deploy. Our compressor station had a spill and the actual sump collected the liquid and it did its job. And so we didn't necessarily have to deploy. We still follow through with an informal remote investigation and get a federally reportable, federally incident report form filled out and completed and submitted. But this doesn't meet the significant incident like the the explosion back in September.
So these could be considered more like a near miss rather than a full-blown accident.
Yeah. Mr. Chairman, Commissioner Nelson, I know you've been brushing up on your language and pipeline safety, but yeah, near miss is a common term we use. But I kind of find it funny that we use the word near miss whenever something actually gets hit. I don't know if you've had that discussion with sometimes near hit maybe, or actually hit, maybe a new word we should use.
Okay. And I did have one follow-up question with regards to our gathering pipeline program. When does the pipeline division take responsibility for the gathering pipelines?
Mr. Chairman, Commissioner Nelson, we've already taken responsibility for those gathering operators and pipelines. We are still working with the feds and industry to identify who that applies to. We have since identified about 22 new operators. And you've heard the number 30,000 miles in New Mexico. Gathering is then further defined by type A, B, C, and then R. I think a lot of these may end up in the R category, which means they'll have to do annual reports and also give us telephonic notice of incidents and accidents. They may not have to comply with the entire federal regulation at this point, but as we gather data, the theory behind it is what additional regulations should apply to these operators. Let's find out what they do, how they operate, get some data points from them because we really don't know anything about them nationally, and then determine what should be applicable or not. And that'll be another rulemaking that PHMSA would adopt.
Has it been determined that, this will be gas as well as liquids gathering?
Mr. Chairman, Commissioner Nelson, good question. I should have clarified that the gathering rule is only applicable to gas. There's gathering rules that are already in place for the liquids, and so those have already been under our jurisdiction for a few years.
Is this going to require revisions to our rules?
Mr. Chairman, Commissioner Nelson, that would be part of that rulemaking that I mentioned earlier.
Oh,
We'll be revisiting the parts, it's actually parts 1 through 5 of Title 18, Chapter 60.
okay. I see. That's what you meant by the PHMSA.
Yes.
Okay, got it. Well, thank you so much for the presentation. Again, thank you for the work that you're doing with your division and making sure that they're trained and developing this.
Thank you. Thank you
Ready
for
to
your support.
back. Thank you. We have one more discussion item by Arthur O'Donnell and Yvette. Yes, Susan, hope I'm saying that right.
Chair, Commissioner Ellison, thank you very much for giving us the time. We just wanted to provide some context for the announcement last week of a $156 million grant to the state of New Mexico under the U.S. Environmental Protection Agency's Solar for All program. There is no action that's required of you, although I do think that this calls for something of a celebration of collaboration, successful collaboration between the Public Regulation Commission and the Energy, Minerals, and Natural Resources Division, who is the actual grant recipient on this. I just want to provide a little bit of context, and then Yvette will give some more details on it. So you may hear some of the same thing from both of us. We've been working with MNERD for over a year on this application. When we first approached them, we had thought about filing an application solely for the PRC with the intent of trying to get EPA money to help develop a investment fund that could help pay down some of the high costs of interconnection for community solar projects, right? The Solar for All program is really geared towards low-income customers and communities. In fact, 75% of the money that is allocated through this program is supposed to go and help low income. When we heard that MNERD was also putting together an application for similar types of outreach for tribes and rural co-ops, we joined forces. Our first ask was $400 million in total. EPA got so many requests in that notice of intent that they asked everybody to go back, sharpen their pencils, and come down. So the actual application that was filed in October was for $250 million. And our understanding with MNERD was that we would get 20% of the grant. So we could call it $50 million out of a $250 million allocation. The money would go to three things. One is the fund that I talked about. The second would be for administrative costs for community solar in the 5-year period for the grant, so that we could work with the legislature on developing a long-term permanent funding solution for community solar. You've heard me talk in the past about how we are restricted in funding for that application to just application fees. And we really needed to find another source. So this represented another source that does not put any burden on New Mexico ratepayers who may not be involved in the community solar program. And the third component that Yvette will talk a little bit more about is providing money for the health and it's human services. I keep getting the federal and the state mixed up. The human services department to essentially build a customer management platform for their low-income constituents, which include the LIHEAP program, the federal LIHEAP program, right? So with the grant, I mean, so many people applied for this is that EPA had to cut down the asks for just about everybody. $156 million is pretty much in line with what other small states got. I looked at New Hampshire, I looked at Maryland, I looked at New Jersey, and that's about what they got. Larger states like New York and California, of course, got a somewhat bigger portion of it. We do not yet have guidance from EPA as to whether they just expect us to prorate down all of our asks, or if there was something that they wanted to emphasize or not emphasize. The only good news that we have is that in EPA's own news release about this and subsequent information was that New Mexico is pretty much the only state that asked for infrastructure money in this case, right? That could be this kind of fund. So we think that we're in there, we're in the clear. We just don't know how much exactly we're going to get. If we stick to the 20%, then it would be on the order of $30 million, of which perhaps $5 million could be associated with the administrative costs, and then have a $25 million fund. It's still a lot of money, and it's still really worth celebrating that this is, I think that MNERD told us that it's the largest grant that they've ever been involved with, and will do a lot of good for the state. We have committed in the application for a stakeholder process, once we know what we're going to do, to help determine the policies for allocating the grant money among community solar projects. You heard me talk about a month ago about the very high costs for interconnection that all of these projects are facing, ranging from $200,000 for interconnection on a simplest basis up to $12 million in some cases. Those are the extremes. Really, what we'll end up being targeting would be the projects in the middle that are facing over $1 million worth of interconnection costs, and it may really be detrimental to their financing if they have to put all that money up and it doesn't pencil out. So we're going to have to devise the process around that. There will be a stakeholder engagement that's built around that. So you'll be hearing more from us on the details of that. I'll just turn it over to Yvette now to talk about some specifics, particularly our work with HSD.
Yes. Hi, everyone. Thank you. So the ability to support the Human Services Department with this funding is something that I'm particularly excited for, as I work closely with HSD through the pilot implementation of the Clean Energy Connector in New Mexico. So the connector is a tool that will help our program subscribe low-income households by providing them a warm introduction to the program from their local LIHEAP office, a source low-income households trust. Through this funding, HSD will be able to make the required changes to their documents and applications while updating their data systems to make low-income verification easier through the connector and other future initiatives. The funding will also allow them to train employees, share community solar educational materials to households, and begin the process of applying LIHEAP credits to community solar bills once we're ready for that, as the current two-bill system makes it hard for households to efficiently make use of utility assistance programs like LIHEAP. We expect the connector to be fully operational in New Mexico by the time community solar projects are energized and acquiring subscribers. And that's some of the nuance behind what we're doing with HSD. Thank you for letting us announce this exciting new opportunity for our state.
And we're open to any questions.
Thank you so much for the work that you did on this. I think it's amazing how an idea can come to fruition. I mean, it's not fully to fruition, but I think we're definitely on the right track, and this is indeed excellent news for our state. I do have a question with respect to you noted something about how EPA will want us to use the money. Are we expecting further instructions from EPA, or will it be between the states that are involved? I mean, not the states, the agencies.
Well, we've already begun the conversations with NMPRC and the State Energy Office that is the actual recipient of the grant. They're waiting to hear from EPA. Now, there were a total of over 60 grants within this program. And so everybody was facing the same downsizing situation. So we just don't know what EPA is going to do. I'm just operating under the assumption of our agreement that we will have a pot of money that's significant, and no matter what the final value is, that we do have to go through a process that will lead to a commission decision as to how to allocate this money.
Okay, thank you. Commissioner Ellison?
I did want to ask, is there a specific time frame for spending this grant money?
Yeah, this is a 5-year program, so all of the funds would need to be expended within that 5 years. That gives us a lot of flexibility in that, depending on what we decide, it also provides an opportunity not just to have bridge administrative costs covered for the program during this period, but also, if we can, set aside some of that money to help identify where a next tranche of community solar projects could be built, and then be partners with everybody that's involved in this in helping to put some resources into developing an optimal location for projects that or several optimal locations. So, I'm really looking at, we have an immediate need. NMPRC's need is kind of over the whole 5-year program, but then we have the opportunity to set ourselves up for the future, and that's what I'm really hoping for.
It does seem to me the one lesson that came out of this first tranche is that we had the submissions first, and then the awarding of bids, and then only after that was it clear what the interconnection costs might be. And I'm wondering if for our next tranche, if we could do something here to make the interconnection costs more evident earlier in the process.
Yes, and that is something that I've been working on, of course, through the technical assistance projects, and you're going to be hearing more about them next month as we wrap up the feeder constraint study with PNM, and maybe are getting to the place where we can announce a new technical assistance support program with the Department of Energy. But yes, that is part of the goal, is that we always knew interconnection was going to be a big hurdle for these community solar projects. That's true all around the country. We didn't know exactly the situation, and now we have a lot more information about it. And I think that we can successfully use that information to develop a way to identify places where the interconnection costs will be lower and more predictable from the outgo. And then that would change the nature of a new tranche of community solar proposals, so that they would not be just, coming in with applications and then have to do the interconnection. Maybe we could get some of the interconnection groundwork done in advance, and people would bid to site their project at that location. That would be one thing that is possible, and I'm going to be developing that idea.
And I just want to confirm that we would be looking towards a commission decision on how to allocate those funds that would help defray interconnection costs for the community solar.
Yeah, and this is not going to take the form of a rulemaking or anything. It could be on the order of a resolution or a memorial that the commission passes just to adopt this. I'm sure that we'll have to work out a further MOU with MNRD about the administration of these costs. But all of that will come before the commission sometime this calendar year, I'm sure.
I'd like to commend your initiative on this, Mr. O'Donnell, and everyone else who worked on it from the PRC. I think this was a great idea to get some funding to defray these interconnection costs, and wouldn't have happened without initiative. So I appreciate that.
Thank you. I'd be remiss if I did not mention Mary Jane Parks, who's now with the utilities staff, who also was one of the main drivers on the application. And Yvette is our community solar fellow, who's 10 months into a 12-month term. And I believe this is the first time you've gotten to talk with the commissioners directly. So these are your resources, and we're doing the best that we can with them.
Thank you. So I just want to follow up on a couple of things that Commissioner Ellison said. One of them with respect to allowing the potential projects to be further informed about where they would want to interconnect. I wholeheartedly agree with that. I think the more information that we could provide, the better. Arthur, you said that would change the way that projects would be submitted, and I'll go even further and say that would drastically improve the program. I think, by allowing them to have a better idea of what is feasible in terms of interconnection and what is not. And then as to, how the money will be used, I certainly am interested to see what recommendations you all come up with. I have ideas in my head, but won't get ahead of myself. But if you want to talk at some point, I'm happy to give you my ideas. And yeah, so again, thank you, both of you and Mary Jane, and appreciate the collaboration with MNRD. And this is good news and a good item to end our agenda with, except for all the procedural stuff. But
thank you very much.
Thank you.
Next, we have communications with Chief of Staff.
Good morning, commissioners. Don't have a whole lot to update you on. Obviously, the agency is churning things out and staying super busy. But I did want to highlight one thing that's probably worth talking with you and letting people know about. And you've probably noticed it entering the building, and that is a sign-in sheet for visitors, a stop, do not proceed, don't pass go until you sign in. We're going to be updating the protocols surrounding entry to our building. You've noticed over the last couple of months, we've been working on getting a security system that functions reliably. We think we've addressed that we're implementing a sign-in process, some things to look forward to. Well, some things that are coming down the pike is maybe a better way to put it rather than looking forward to it. But we'll be hopefully issuing employee badges with picture identification on them for employees to have during their time in the office, as well as visitor badges so that we're clear about who should be in the building and who should not be. Obviously, this room is a public space during open meetings and other public hearings. And the lobby is a public space, but we have some portions of the building that is not public. And so we're going to be making that signage much more clear. And just as the summer goes on, I think you will be seeing a policy on physical security coming forward. So let your visitors know, if they're regular visitors, to expect changes in accessing the building.
Appreciate your initiative on that. I think those are all positive changes.
Thank you for that as well. And then next we have communications with commissioners. The only thing that I want to just sort of mention is that I've been thinking a lot more about water. Was in some presentations about PFAS and PFOA, and more frightened than I was before that. And I've been looking at some of the annual reports that the water companies that we do regulate have filed, and I don't have any suggestions, but at the moment, but I'm kind of wondering if there are ways that we need to improve just for health and safety. And I spoke recently with some commissioners across the country, and there are some commissions that are doing more because they've been placed in a situation where they've had some major incidents. Not that we don't hear. I mean, currently, Sullivan Park, New Mexico, which is the community that I grew up in, is having really big issues with their water. There was an article in, I think it was the Washington Post recently about that. And that's not good. And so anyway, just wanted to mention that, and I'll continue thinking about it and maybe be reaching out to some staff to learn more and see what ideas they have as to whether there are areas where we need to improve. And that's all that I have in terms of communications.
Great, thank you. I might mention that all members of the commission were present at Western Interstate Energy Board meeting in Denver late last week. There are so many acronyms used at these meetings, it takes a couple of meetings to figure out what people are talking about. And I found the last meeting particularly useful. I've mentioned before the issue with this Western Resource Adequacy Program, or WRAP, to use another acronym. I think it's interesting that the utilities that have joined this organization did write a letter to the Western Power Pool leadership. They're organizing this this reliability program, and stating that the current FERC tariff that is filed for this RAP reliability program has a transition period where the program does assess penalties if a utility is not able to meet the reliability requirements. And there's a transition period where, you know, the penalties are less than when the program is in full implementation later. But even so, these utilities were requesting an amendment to the FERC tariff to further make the initial fines to be much less. And, you know, that's interesting on several levels because previously, I think the Western Power Pool people thought that, oh, maybe there are a couple of these utilities that are short on capacity and that's it. But with everyone signing on to this letter and everyone concerned about these fines and asking for a FERC tariff amendment, it seems clear that there are a lot more utilities than were thought actually do have resource adequacy problems. And so it's also clear that they're not going to go live essentially with this program in the summer of 2026, as was thought previously, but it would happen later, and exactly when that later is, it is still a matter of discussion, and you know, does depend on the ability, it seems, to do an amendment to the FERC tariff. And I might just briefly comment, you know, what this resource adequacy program actually does. It's not a contingency reserve, which would be, you know, you've got a power plant forced outage and you need replacement power right now. You know, that's not what it does. What it's designed for is, let's say you've got an unexpected problem with the generation unit, and you've got to have it out for 2 weeks. Well, in that case, the RAP, this resource adequacy program, would be a backstop that, you know, starting the next day after you've had the problem, you can go out and you can get a block of replacement power for sure, guaranteed. So you don't have to hope that it's available. It would be available, but it would also be more expensive than if you just went on the market and bought it, because they want it to be, you know, a backstop and something you use as a last resort. You know, if, for example, a company were relying on a solar project to come online for resource adequacy, and they knew that supply chain issues are going to delay the project by 6 months, that would not be covered by RAP. They would say, well, you should go out and do a bilateral contract and get your replacement power, since you know 6 months in advance you're not going to have it. You know, I thought that you know, the developments around this Western Resource Adequacy Program are very interesting. You know, there was a lot of discussion about transmission, as you would hear at these conferences. One speaker in particular I think it was from Rocky Mountain Institute, did this analysis looking at Western state pairs, which, having transmission between which states would be most beneficial. And the highest one on the chart was Washington State and New Mexico as being the absolute, dream combination, because here we obviously have the solar and the wind, and there they have the hydro. And so if there were a way to get, adequate capacity between our two states, we'd be in pretty good shape. But, no one, it seems, is going to do a merchant transmission line for that when, you don't have any 20-year contracts that you could, sell power for. And I do think, although it didn't really come up at the conference, we're obviously, there are a number of merchant transmission line projects that, are anticipated here in New Mexico, between New Mexico and California, Arizona. And, for example, the SunZia line, unless, there is some interconnection at that initial AC to DC station, then, that new transmission line would not help in terms of regional markets. It would solely exist to send wind from New Mexico to Arizona and California. And because would be supplied by wind generation, a lot of the time, the transmission capacity would not be used to its fullest extent. And so, thinking about, how could projects like this benefit the regional market and regional power exchange, I think those are fruitful conversations. And, you don't hear them a lot at these meetings, because I don't think many other states are in the position that we are in with, the amount of merchant transmission line capacity that may go in. I might just mention on a personal note, I do plan to be out the latter 2 weeks of June. So I will need to speak with Mr. Cameron about the open meeting that we've got towards the end of June. I most likely will not be able to dial in for that.
Thank you. Well, I thought I was done, but you gave me a lot to think about. So with respect to RAP, I would suggest getting your questions ready for CAISO and SPP for when they come in a couple of weeks, because I think they'll be able to answer some of those. I mean, they're not RAP, but certainly they are very well versed with how RAP will work, because they need to think about how it will integrate with their day-ahead market designs. And related to that, I did want to clarify a comment that I made, I think, at the last meeting, or maybe it was 2 meetings ago, when we were talking about RAP. I noted that for Markets Plus, a participant there, well, LSE or LRE as how they call it, but anybody serving load will need to join RAP. And I said that I thought it was the same for CAISO. It in fact is not the same for CAISO. CAISO will be conducting a resource sufficiency evaluation, which according to SPP accomplishes sort of the similar thing. I think there's, it kind of, for me, raises some questions that I want to talk to SPP about how Markets Plus will ensure sufficient transmission, because not all, since they're not doing the same resource sufficiency evaluation as CAISO is, and in RAP, my understanding is not all participants who are providing transmission to the market will be required to be members of RAP. And so I had also noted at the last meeting that the Markets Plus States Committee, which is a committee that I've been assigned to, so as one of my responsibilities, was thinking about submitting comments. The MSC did in fact submit comments, and I sent those to, I think Cynthia sent those to Judy, and they're posted on FERC's website, and so you can have a look at those. And similarly for the BOSS, or the Body of State Regulators, so this is the state committee of basically members who are in the WEIN. For that, the committee has been pretty involved as well and submitted some comments to CAISO on what they call their roadmap. So this is just kind of the initiatives that CAISO plans to undertake in the future. So we included things like greenhouse gas accounting and tracking, and so that is ongoing. With respect to the an ideal transmission line between Washington and New Mexico, that would be excellent. I think it'd be rough when there are like low hydro years, but on top of that, a lot of these hydro units in Washington are leaning towards joining Markets Plus, and the design in Markets Plus is such that any resources in Washington, because it's its own GHG zone, will be deemed dispatched to Washington. And so I think it would make it, even if we had that transmission, I think that the market design would make it difficult to actually obtain any benefits from that.
Unless there's a bilateral contract that could be done.
Well, not if they're in the market. Not if they're if the owner is in the market, then it will be dispatched in the market. So I guess if that transmission provider does not join Markets Plus, then they're not subject to the market design rules, and therefore, yes, I think there could be a bilateral contract. But outside of that, no. Which to me is a drawback of the market design. I think that it creates inefficiencies, and this is all due to the fact that Washington has a price, they have a cap and invest program, and so they're pricing carbon, and a lot of attention was put into how Markets Plus will accommodate that greenhouse gas program. And that is, part of the comments that the MSC submitted as well, is that the interaction between that GHG zone and other zones, so sort of like New Mexico, which would be like we don't price carbon, but we have RPS standards that utilities need to meet, that it was not fully I guess there's more work to do on it. And then With respect to SunZia, I'm gonna push back on the comment that that wouldn't be useful for regional markets. I think it would be for example, for EDAM, since a lot of that, since that generation is subscribed to meet load in California. Similarly, and you know, I hope we talk about this further at a future meeting. There are transmission rights on other lines. You know, I know that, for example, PNM and El Paso Electric have transmission rights coming from Palo Verde to New Mexico, and I believe there are plenty of transmission rights also coming from the going from the Four Corners area to California. So I think, you know, that's one thing that I'm very interested in exploring. And my understanding is that PNM has a study that is being commissioned by the Brattle Group, which will delve into these issues. And so you know, that's a workshop that I am really looking forward to having sometime this summer, so that we can see what the transmission looks like. But I do agree with you that as a DC line with no way to offtake energy in New Mexico, it, you know, for now is one directional. The other thing is there's the Rio Sol line, which is runs parallel to SunZia, which is an AC line. And that will have, I think, 1,500 megawatts of capacity. Yeah, you know, just kind of a lot of potential things that I'm really glad that we have these workshops to sort of hash out. And then I think that was all I wrote down. How are we doing on time? Oh, we're doing great on time.
Yeah, I might just mention, you know, that really was my point about SunZia, that given that it's a high voltage DC line, you know, your ability to send power back to New Mexico is not going to be available unless you've got a transmission line that connects into that AC to DC conversion station where the you know, where the wind project is located, which is doable, which is possible. You know, I guess on the market design, you know, I do think it's interesting and important to get into some of the details of how the markets would work. You know, my understanding of, you know, at least the EDAM, the day ahead market, is that a utility that's part of it would have to decide which power plants they're going to allow the market to dispatch. So I mean, just to make it clear for everyone listening, the stay ahead market thing is it's a big deal, because instead of a utility dispatching its own power plants, somebody in a central location would be dispatching all the power plants. But the utility, my understanding is that they would get to decide which power plants they're going to allow to be dispatched and which ones, you know, they're going to dispatch themselves. So, you know, I do think it's an interesting question whether, you know, there might be the ability to do, you know, even with the market, bilateral contracts, you know, around the market that could, you know, take the RECs, the renewable energy certificates into account and allow them to be transferred. I did want to mention also that May 9th and 10th, I plan to be at a CAISO Markets workshop. Our economics advisor, Miguel Perez, is going to be joining me for that workshop. Also, right now I am intending to attend this NARUC Western Commissioners meeting May 20th through 22nd. I had no travel until last week in Denver, and now it looks like there's a lot of it coming up. But and I'm undecided about this summer NARUC session in July, whether I'm going to go to that.
Okay, yeah, I also have, I'm also undecided as to whether to attend the summer NARUC session. And then I will be attending the Western Conference of Public Service Commissioners in late May. It's like May, I don't remember the dates. It's actually like the 22nd to 20. No, I shouldn't say it because I might just say the wrong dates, but it's later this month. We are in May, aren't we? Yes. And then just to note for everybody also, I probably should have said this during the announcements, but Jennifer Baca, our executive assistant, is in the process of looking at locations and dates to have some regular open meetings outside of Santa Fe. So I'm really excited about that. You know, I still don't know exactly what locations they're going to be. I know that one of the ones that I suggested was Hobbs to be in SBS's territory, and then another one in El Paso Electric's territory. No offense, PNM, but I think it's just whenever we have some concrete information on that, we will absolutely let you know as soon as possible, so that you might want to attend one of these meetings in a different location. So so I think with that, I think I'm actually really done this time. Commissioner Ellison,
Yeah, I agree. Those out of town meetings, I think are really important and interesting, and I do hope we can find a local connection when we're in these other cities, such that the local community would feel some relevance to some of the issues that they're having.
okay, well, it's 12:01, and with that, unless there's any objection, I think we're adjourned.